Court records are meant to show how justice is delivered, but not every case ends with a ruling. Some outcomes are decided quietly, through process, timing, and final paperwork that never reaches open court. These are those cases. This is what happened before the gavel fell.
The notice does not say decision. It does not say ruling. It says final administrative action. Daniel Reyes reads it slowly because he has learned that words matter most when they are chosen carefully. The notice explains that the court has completed its review, that all required steps have been taken, that interim measures were appropriate, timelines were observed, and no outstanding issues remain unresolved. It does not summarize testimony. It does not weigh arguments. It does not explain reasoning. Daniel looks for the word verdict. It isn't there. He calls his attorney. The attorney has already seen the notice. "This is it," the attorney says. Not dramatically, not gently, factually. Daniel asks what it means. The attorney explains that the case has reached administrative finality, that there will be no further hearings unless new information is introduced, that the court considers the matter closed for purposes of action. Daniel asks whether that means the case is over. The attorney hesitates. "It means the system is done with it," they say. Daniel reads the notice again. Final, administrative, action. He asks what happens next. The attorney explains that the court will issue final documentation confirming the outcome already in effect, that nothing new will be imposed, that nothing will be lifted either. Daniel asks whether there is anything left to challenge. The attorney says no. "Not really," they add. Daniel asks why there was no hearing. The attorney explains that hearings are for disputes. This case no longer has any. Daniel asks how that happened. The attorney answers honestly. "It became settled," they say. Settled. Without agreement. Without argument. Without a decision spoken aloud. Another document arrives later that day. This one confirms that prior measures are now considered permanent pending further review. Further review is not defined. Daniel notices something strange. There is no appeal section, no instructions, no deadlines, just confirmation. The attorney explains that administrative finality does not operate like a verdict. There is nothing to overturn, because nothing was technically decided. Daniel asks how that can be true. The attorney explains that the outcome was implemented gradually, through compliance, delay, and procedure. By the time the system reached final action, there was nothing left to rule on. Daniel asks whether a judge signed off on this. The attorney explains that a judge authorized the process. Daniel asks whether the judge reviewed the final notice. The attorney does not answer directly. Daniel sits with that. The room feels smaller than it did before. Not because of walls, because of closure. Daniel realizes something unsettling. This case will not end with words spoken from a bench. It will end with silence. That night, Daniel goes through every document again, the transcript, the notices, the acknowledgments, the procedural updates. They form a clean line, one step leading to the next, each one justified by the last. He sees it clearly now. There was no single moment where everything changed. There was no dramatic turning point, just accumulation. Daniel understands why it feels so empty. Because there's nothing left to argue against. The system did not rule against him. It finished around him. The final document states that Daniel Reyes has been afforded due process, that opportunities were provided, that actions taken were consistent with policy. Daniel reads that paragraph twice. Due process. He realizes something important. Due process does not require justice. It requires procedure. Daniel asks one final question. When did this actually end? The attorney does not answer immediately, then says something Daniel will not forget. It ended when there was nothing left to contest. Daniel understands. The ending did not arrive today. Today is just when it became visible. The record will show that Daniel Reyes's case reached final administrative action on a specific date. It will not show when the outcome became inevitable. That happened earlier, quietly, before anyone said it was over. And now, with nothing left to appeal and nothing left to argue, Daniel is left with a question he can't shake. If the case ended without a ruling, without a verdict, and without a moment he could point to, then when exactly did the gavel fall?